Hello folks, welcome to Legacy IAS Academy. In today's video, we will be discussing about the emergency provisions. This video is presented to you by your faculty, Sushma K. So in emergency, we have three types of emergency: national emergency, state emergency or precedence rule, and financial emergency. Just a small recap we will have about your national emergency, which was declared during the period of your 1975 to 1977. So the backdrop where it happened was your Allahabad High Court had more of found Indira Gandhi guilty of electoral malpractices, and this was in your June 1975. At the same point of time, there was also huge political unrest that the Prime Minister at that point of time, Indira Gandhi, was facing from your opposition. That is, Jayaprakash Narayan was constantly asking the Prime Minister to Fakhruddin Ali Ahmed to declare emergency based on internal disturbances. Once this was imposed, a lot of things started happening. For example, civil liberties were curbed, your mass arrests were seen, and also one important thing that was also seen here was your forced sterilizations, and this brought in a large number of constitutional amendments. That is your 42nd amendment, which is also called as your mini constitutions. So, what people started seeing this phase of emergency was as weaponizing of laws. Technically, on legality, they were not wrong, but this led to weaponization of laws, trying to use legal loopholes. These are considered as the backdrop or slide of democracy. This is where your democracy goes and dictatorship comes in. So your democracy was considered as a very more as the phase where democracy would be now uncertain. So the emergency period was considered as a dark chapter in India's history. This is just a small glimpse into how the emergency period was. Now we will be discussing in depth about your emergency provisions from all three perspectives of your national emergency, precedence rule or state emergency, and your financial emergency. Look at this. First and foremost, emergency is contained in your part 18. It is from articles 352 to 360, wherein your 352 is your national emergency, 356 is your presidential rule or your state emergency, and your 360 is financial emergency. What is the need for the so-called emergency provisions to be there in our constitution? First and foremost, to protect sovereignty, integrity, and democratic order during the crisis situation. This is more like to be used in rare scenarios or to be used when normalcy cannot be contained. It could be for any number of reasons. Understanding? Now, what are the types of emergency? National emergency under Article 352. This can be imposed on the grounds of war, external aggression, or armed rebellion. Now look at the word here. This armed rebellion was brought in from your 44th constitutional amendment. Before this, it was internal disturbances. Understanding? Your precedence rule or your state emergency under Article 356, where it is a failure of constitutional machinery, that is the grounds on which you can impose precedence rule. Then last is a financial emergency, that is under Article 360, wherein it poses a threat to the financial stability of the country. So these three are the grounds on which emergency can be levied. Now we will see about your one by one national emergency. First and foremost, who can declare national emergency? National emergency can only be declared by the president on the aid and advice of Council of Ministers. See, in your emergency period, that was in your 1970s, what happened was the Prime Minister told the President to impose emergency. The Council of Ministers were informed a day after the emergency was imposed. Understanding? At this point of time, legally they do not do anything wrong, but at the same point of time, this was the more of a stage setup for a dictatorial tendency. So in the 44th Amendment, a changes was made that President has to listen to the aid and advice of COM. Yes. If emergency has to be imposed, Prime Minister alone cannot tell the President. The Council of Ministers are supposed to tell the President to impose emergency, and that too, it is not to be verbal, it is to be in written form. Understanding? So, if emergency, national emergency has to be imposed, the Council of Ministers have to give the President in writing. Okay, this was the changes that was made in your 44th Amendment. Then, on what grounds can your national emergency be imposed on? First and foremost, war, external aggression, or armed rebellion. Okay, this word armed rebellion was added in the 44th Amendment. Earlier, it meant internal disturbances. What will happen? Let's say your national emergency is imposed by the president. What will happen? First and foremost, the changes that will start affecting is we are a federal structure. This federal structure that is between a center and state will become unitary. So when you're KC Weir, okay, this is where you can mention these people. Already calls that we are quasi-federal. We do not have complete federal nor do we have complete unitary. But there are provisions like your emergency where center amasses that power, large amount of power, or it becomes unitary in nature. Understanding? Another thing is with respect to legislative powers. How are the legislative powers getting affected because of emergency? Your parliament can legislate in the state list also. See, in your seventh schedule, there is a strict rule: union list, state list, concurrent list. In normal scenarios, your parliament can only legislate on union list and concurrent list. But during your emergency, it also gets the provision to legislate or make laws on your state list items. Then, how does the executive power be altered in your during your emergency? The executive directions of the center, which means whatever the center tells, it is applicable throughout the territory of India. Again, why these draconian powers are given? First and foremost, the explanation they are giving is this is to protect the sovereignty and security of India. For that reasons, this has to be needed. What happens to your fundamental rights? See, I told you 352, 356, 360. These are the articles which are for your emergency. Other two articles you have to remember is your 358 and 359, which are also related to your emergency and fundamental rights. Under Article 358, Article 19, which is a fundamental right, can be restricted. Under your Article 359, all the other fundamental rights, whichever one you want to be restrictive, you can accept exception of Articles 20 and 21. Okay, this too will still remain even if there is a emergency. All right, this is with regard to your consequences of your national emergency. Now we saw that emergency was considered as a very dark period. Civil liberties were curbed. There were huge amount of mass arrest, forced sterilization. The threat of constitution or constitution continuance became a threat. That it also became a threat to the democracy itself. So based on all these things, what do you think the later committees which were set up discussed or that they recommended how your national emergency should be used? See, first and foremost, according to a Sarkaria Commission, they have held that emergency provision should be used only as a last resort when there is no other option and not as the first step. According to your Panchi Commission, it has also said that first and foremost, usage of emergency should again be last resort, and foremost thing is This should not be used as an option to suppress the states. The federal structure or the federal features between center and state have to be improved. Understanding? Now, what exactly or when exactly we have seen the instances of war? Understanding? See, 1962 Indo-Sino War, 1971 Indo-Pak War, 1975 it was declared by Indira Gandhi on the grounds of internal disturbance. First and foremost, with regarding to restriction of fundamental rights or suspension of fundamental rights, how the judiciary has viewed it over the course of period, and how the judiciary has made changes to your emergency and fundamental rights. Here, most important things that you have to know is, in your Jabalpur case, ADM Jabalpur versus Shivkant Shukla case, Supreme Court held that yes, even Article 21 can be suspended during your emergency. This was in your Jabalpur case. Later cases, whatever is to happen, they hold that no, there is no such provision where no matter what happens, that cannot put an imposition on the life. That we can see in your Justice Puttaswamy case, wherein they held that right to life is non-derogable, which means Article 21 will not be restricted even during emergency. In your Minerva Mills case versus Union of India, your Supreme Court here further went ahead and held that the Parliament cannot keep amending the Constitution to whatever extent it likes. There is a limit on the amending power of the Parliament, meaning it has to make sure it does not affect the basic structure of the Constitution. This was upheld in your Minerva Mills case. So, accordingly, despite any emergency, it is Article 21, that is your right to life, cannot be curbed. Next, we will be discussing is about your President's Rule. President's Rule is imposed under Article 356. It will be either told by the governor or if the President deems fit. First and foremost, if you see, it is declared by the President on what grounds? Simple. Failure of constitutional machinery in states. Understanding? Failure of constitutional machinery in states is a broader term, and also the way it is being misused is also very higher with respect to your President's Rule. Meaning, it has been used more than 125 times. The highest of it is used in Kerala. Again, why? Because of your political tussle. Understanding? Now, if you see, who can impose this? Yes, President will impose it. Now, once this is imposed, Parliament has to, that is, both houses of the Parliament has to approve that within 2 months of convening back. And this is extendable every 6 months. They can keep increasing every 6 months, but this can be done to a maximum of up to 3 years only. Understanding? What is the consequence once a president rule is imposed in a particular state? First and foremost, entire state executive powers goes into the hands of your president. Second thing is, state legislature may be dissolved. Look at the word I'm using. Maybe. It is not necessary 100% of the time that it is dissolved. Your executive machinery, the government will be dissolved. That is, but your state legislature may or may not be. The powers of High Court remain intact. Understanding? See, first and foremost, when an emergency is to be imposed during under your Article 352, it can be imposed even before actual war has begun or after the war has begun. Either way, you can impose. That is first condition. Second condition is when your president imposes emergency, the parliament has to approve that within 1 month time. Before that, that is, this changes was done in your 44th amendment. Before 44th amendment and all, parliament has to approve that within 2 months. But whereas in 44th amendment, they changed the date. Is once president has approved emergency or imposed emergency, parliament has to approve that, both houses of the parliament, within 1 month of its proclamation. Another thing is, the way you have to, like, let's say, approve with both the houses, it needs a special majority, which means total membership of the house, that is majority of the total membership of the house, and 2/3 of the members present and voting. Understanding? Now, revoking of this national emergency also, 1/10 of the members have to revoke it. Emergency is approved, it is valid for 6 months. It can keep being extended indefinitely for making sure that it is every 6 months approved. Okay, we've seen for your national emergency, we've seen for your state emergency. Again, in here, like I told you, previous case where you have to remember your Minerva Mills case, Puttaswamy case. Here, one of the most important landmark judgments of your precedence rule is SR Bommai case. Understanding? So, what happened in your SR Bommai case was, he was the Chief Minister of Karnataka. This government was declared, yes, it is lacking majority, and they put arbitrarily dismiss the government and put in precedence rule. He went ahead and put the case. After a lot of years, the judgment came in, which said that, see, under no condition you will arbitrarily dismiss a government. First thing. Second thing, you will conduct the floor test in the state assembly, not in Raj Bhavan, to know the majority. Understanding? Floor test must be conducted to find out about the majority. Next, precedence rule cannot be applied on arbitrary manner, and it should not be applied just on your political tussles. Understanding? So, in your SR Bommai versus Union of India case, it was held that floor test is the sole test of majority to prove the majority, with under which your SR Bommai government was dissolved, telling that it has lost its majority. Judicial review is applicable for Article 365, and if at all you are going to tell a particular state is not following, or it has violated the constitutional principles, you have to first see and make sure that it is breakdown of the state machinery, and not for things like, yes, corruption is there, now I'll impose precedence rule on that. Understanding? So again, here also, if we see, we will bring in the same things like we used in your national emergency. The recommendations of your Sarkaria Commission and Panchi Commission. Emergency provision should be used as a last resort, and you have to make sure you strengthen the federal relations or center state relations. And another thing is, in your Panchi Commission, they have held that the powers of governor, if not constitutional, they have to be more of codified. You have to tell this is the governor's power. Why are you telling that? To limit the powers, to end the discretion to a larger extent, if not in official duty. The next is your financial emergency. Financial emergency, again, president is the one who will be the one to invoke it. Up until now, financial emergency has not been imposed, even though we had 1991 BOP crisis, or your COVID-19 year times, there was a huge financial issue. That time it was discussed, but it was not recommended to impose financial emergency. Again, for this, parliament approval is needed within 2 months of imposing financial emergency. So now what will happen if you impose a financial emergency? First and foremost, the center has, that is under this, you can reduce the salary of your center, states, judiciary. The president can issue the directions to the states with regarding to the financial matters, and also they have the power to even reserve the money bill. So basically everything under the financial ambit comes under the control of your center. Now, what are the concerns with regarding to this emergency? First, there is a threat of financial autonomy between your center and states. Another thing is, despite very stressed scenarios, it has not been invoked, and even if it invoked, it affects the center state relations to a larger extent. So, what can be done or what was done to safeguard against this emergency provisions? Under Article 352, the changes that we discussed, first and foremost, have to tell the president, and it has to be a written version, not a oral one, and not just the prime minister alone. And parliamentary approval is needed within 1 month of time, and every 6 months it will be reviewed. With respect to Article 356 or President's Rule, parliamentary approval is to be done. Floor test is the only source of counting on your majority. Judicial review is applicable to the President's Rule so as to make sure that it is not malified. Under Article 360, again Parliament has to approve it within 2 months of time. What we observed is, once your emergency was imposed, your 42nd amendment, which was also brought in, is many times regarded as mini constitution, is because of the excessive centralization it went on to do. Your federalism is a feature of basic structure of constitution, is what your judiciary has held, and when you make these kind of rules, this is directly impacting your basic structure of constitution. So this has to be made sure, that is, the provisions were made sure that the misuse of emergency provisions will not take place. So what were the changes made in the 44th amendment? It replaced internal disturbance with armed rebellion in your national emergency, restored article 20 and 21 despite any emergency being brought in, ensure cabinet advice is in writing so as to make sure it is not arbitrary, and the revocation of emergency allowed 1/10 of the Lok Sabha members to demand for removal of emergency. What are the issues with respect to your emergency or your criticism that we have observed? A, it is extremely centralized, like we see how it was done with respect to your 42nd amendment in your national emergency. Now, when we speak about your Article 356, a lot of governor's discretion is put in. Most times they will be just because of your political tussle cases. Another thing is, for your Article 360, you do not have a clear perspective as to when to impose. So it is lacking an objective. It affects and corrodes the federalism, which is a basic structure of the constitution. And the judiciary's role, time and again, they try to limit it, especially we've seen in your 42nd amendment. With this, one of the largest things that we see and observe as your misuse of emergency provision was large scale misuse, and your civil liberties getting affected. Understanding? So, how can we go ahead? Codify the governor's role so as to avoid political misuse, strengthen the floor test mechanism to prove for the majority, define the threshold for financial emergency, meaning that you have to give a clear cut instructions as to when and under what conditions can financial emergency be imposed. Judicial scrutiny has to be brought in, and also transparency must be increased so as to make sure that you can hold the responsible accountable. And one of the main things is, you increase constitutional morality over majoritarianism, and you make sure you conduct regular audits, and you also bring in a lot of awareness, institutional awareness, constitutional mandate. So basically you bring in the citizens involved into the decision making process. Understanding? Let's see a possible mains question that was asked in your UPSC mains. This is a 2013 mains question. What do you understand by the concept of emergency powers in the Indian Constitution? Do you think emergency provisions contradict the principles of federalism? Justify your answer. See, in this particular thing, first you will speak about emergency, meaning what is it? Okay, this is the condition where in order to protect the sovereignty, that again will diverge into why is it there? To protect sovereignty, protect the security of India, understanding. And the next portion, look at that. What do you understand by the concept of emergency powers? What are the types of emergency powers? Again, we have Article 352, Article 356, Article 360. Okay, herein you will speak about this is your national emergency which will be declared under your war, armed rebellion, external aggression, right? And you will mention the approval methods, who can approve it, your parliament ka approval, understanding. The same thing goes for your president's rule also, goes for your financial emergency also, same things this also will continue. And like the same way how we discussed, what will be the consequence when you do this with respect to your legislative powers, executive powers, center state relations, okay, then with respect to your financial powers, what is the impact of these things, or at least you can take examples when these conditions were imposed. That is, you can tell about your emergency period of 1970s, and you can see your civil liberties getting curbed. You can also mention about your severe pressure on your media, understanding. Your constitutional amendments which were to bring in more centralization. See, they're asking the principle of federalism, it contradicts. This is where you will bring in your 42nd amendment, which was trying to do what? Over centralization. Then again the same thing, you will also speak in of your 356 and 360 also, wherein it affects the concept of federalism in your SR Bommai case, and how the largest number of your governors, that is your president's rule, is extremely misused, right? And here you will bring in judicial cases such as your SR Bommai case, you will bring Minerva Mills case, Puttaswamy case. You will also bring in the concept of basic structure, right? So you will speak of this from this perspective, that is, you will speak how your emergency provision is affecting your federalism. Again, from your civil rights, you will speak about your suspension of your fundamental rights, Article 358, Article 359. You will also here mention about your Article 20 and Article 21, which cannot be suspended irrespective of what emergency you are going to impose, understanding. So these are the key terminologies from your emergency topic, understanding. Hope the topic is clear to you. With this, we've come to the end of the content. If you like our content, subscribe to our channel, hit the like button, share it along with your friends. Thank you.